Great, so we'll go on the record in the state of Wisconsin versus Mason Gunderson. It's a 26 CF 517. There's also a bill bond hearing on a pretrial services violation in 26 CF 11. Could I get the appearances?
John Bake for the state.
Attorney Jeremy Evans appears as a friend of the court for CF 26 CF 11 and on behalf of, I'm sorry, the other way around, my apologies. Appears as friend of the court for 26 CF 517 and on behalf, I'm covering for Attorney Eric Habich, who represents him on 26 CF 11.
Okay, and I guess that leads me to believe that maybe Mr. Gunderson needs to do something to hire Attorney Habich on the new case or retain your firm or whatever. If you're not able to do that, you can always apply for a public defender. The deputy's giving you that information. If you find yourself caught in the middle, you can apply for a county appointed attorney. You've got the new complaint, the 26 CF 517.
Yes, Your Honor, I acknowledge receipt of the complaint. I waive its reading. The address is current.
Right, I'll make findings of probable cause for the charges and are not guilty pleas to the misdemeanors. And then there was a pretrial services violation. I don't know if you've got a copy of that report, Attorney Evans.
I do.
All right, and let me just take a look at that. Yeah, so it looks like the violation was the new arrest, state's position on bail.
I'll start with 26 CF 517. State is requesting $25,000 cash bail with conditions that the defendant not operate a motor vehicle, that he not possess or consume any alcohol, and that he be banned from Club Bristol. As for 26 CF 11, I'd ask that bail be forfeit and an additional $15,000 cash bail along with the previously and stated non-monetary conditions. Here, the defendant's on a $15,000 cash bail in that 26 CF 11 case. It's alleged that he goes to Club Bristol, that he's drinking there, that he stays for a few hours and then exposes himself to a dancer. He's forcibly removed from the club. There's a witness who observes him leaving, driving in his Jeep. His driving's not great. He crosses the center line. He hits another vehicle. Thankfully, the passengers of the other vehicle are not injured to my knowledge, but he leaves the scene and decides to then walk to a bar and order a drink and play slots. So law enforcement enters the bar. He's not truthful about his name. He's confronted. He admits to driving the Jeep, but then starts saying that the other vehicle, he blames the other vehicle, saying they crossed the center line. There are obvious signs of impairment. He refuses field sobriety and as well as a preliminary breath test. Given the blatant disregard for his bond conditions, lying to law enforcement, he's also resistive at the hospital to the point where they have to call security staff and deploy tasers. And given the fact that he was already on such high cash bond, clearly a significant amount of cash bail is necessary. Thank you.
Great, and the defense position?
The defense position, 26 CF 11. We would ask that bond not be forfeited, and that an additional, a modest additional cash bail for that of $1,000. As for the present case, the most recent, we would ask for a lower cash bail, $1,000 or $2,000. And that the court consider electronic monitoring and alcohol monitoring, given that these incidences involve alcohol. I think that making sure that he is alcohol-free will probably ensure his bond compliance moving forward. He does care for a child of his partner's. He's in the middle of closing a business. He has therapy and a therapist appointment and psychiatrist. He's under the care of both a therapist and a psychiatrist. He has major depression and anxiety. So that's what we would ask of the court.
Great, and any response?
No, the state rests on its previous argument.
All right, well, it's quite concerning that we're back here. I think this is now the third case that's open. He had a significant cash bail, had the pretrial services. There's not a lot more that I can do other than increase the cash bail. The statutes say that the cash bail can be forfeited for violating conditions of bail, picking up new cases, missing court. In fact, they say shall forfeit with the ability to have that overturned if it's not in the interest of justice. I don't believe Mr. Gunderson specifically posted that bail, as I understand the bail sheet. I think that's something relevant to take into account here today. But I don't see the ultimate result as simply modest cash bail. Because quite frankly, if I forfeited the $15,000, you would have that lost, or whoever posted that for you. And there'd still be a good argument for a bail higher than $15,000 in that particular case. So I'm not going to forfeit it because I think somebody else posted that. If they're watching, they should be on notice. If we're back here for future violations, I don't think we've got much choice other than to forfeit that bail. And these are significant sums, I assume, to that other person. I'm going to set $30,000 cash bail in 26 CF 11. That takes into account I'm not forfeiting the 15,000. I'll order pretrial services with the prior conditions. In 26 CF 517, I think $5,000 is sufficient. I will order pretrial services there. I do think that there needs to be monitoring for alcohol use. So you'll be equipped with a breathalyzer this time in addition to the GPS that you had previously. I'm going to order that you not operate a motor vehicle, that you be banned from Club Bristol. I'll also order the GPS in that new case to monitor the address ban. And you're obviously familiar with their offices. They've given you the map again. You got to be there no later than 10 a.m. in the business day following your release from custody. As to time limits for the preliminary hearing.
We would like to, I just wanted to clarify for CF 11, a total of 30,000, including the 15.
Total of 30,000. He has 15,000 that applies because I declined to forfeit that.
Okay, so another 15. Okay.
That's why I set it as high as I did, because I wasn't forfeiting the bail.
We would like to have the preliminary hearing within the time limits.
Okay, if you've got a calendar or Attorney Havich's calendar, the clerk will let you know we've got available for date and time.
So you're looking at March 10th, 3 o'clock.
I'm afraid he is not available then.
At the 11th at 1:30.
That's cutting it close. He has to be in Columbia County in the afternoon. Actually, that might work. You said 1:30?
Yes.
Okay.
Right, we should go with that date then?
Yes, that'll work.
Okay, we are adjourned. Thank you.
Next up is Samuel Journey. Hearing by Zoom.